All right, I'm speaking now with the Dean of the St. Louis University School of Law, Michael Wolff, who, among other things, is a former member of Missouri's Supreme Court and served as its Chief Justice from 2005 to 2007. Very glad to have you with us today. Thank you.
Good afternoon.
What we're going to talk about today is with Missouri's veto session coming up in 13 days as you and I speak. One of the bills likely to be brought up for a potential override will be House Bill 150 that deals with Missouri's unemployment benefits. And to give our viewers and listeners a little bit of background, now that veto was brought up by the House and overridden during the regular session. And the Senate, Republican Senate leaders say they want to bring it up then in the veto session that's coming up in a few days and attempt to override that veto. And you have some, including Governor Nixon, who say they can't do that because the House already overturned the veto during the regular session. The Senate can't now bring it up. And that's the main question that we want your take on. What's your observation of how this is playing out?
I think that the Senate missed its opportunity when it didn't vote on it during the regular session. And I say that because the Constitution of Missouri sets up a pretty clear roadway for how the vetoes occur. And what it says is that when the House and Senate pass a measure and present it to the governor has 15 days in which either to sign it or to render his objections to it. If he objects to it, that means he vetoed it. Then it goes back to the House where it originated. And if it's later than 6 days before the end of the session, it will be taken up in a veto session in September. But if it's presented to him and he vetoes it before that end of the session, essentially the last week of the session, then it has to be taken up in the House that originated it, and there's enough time for it to be taken up in the other House, the Senate in this case. And so there's a preference that's in the Constitution for doing this during the regular session of the General Assembly, because you only have a veto session if there was something that was vetoed after that timeline. Now, the governor could have chosen. In this case, I think he vetoed it on May 5th, and the end of the session was May 15th. I'm not sure exactly what day that the legislature passed this bill and presented it to him, but I think it was a few days before then. He could have chosen to have vetoed it during the last week of the session, or even after the session, if I'm doing the math right. And then it would have gone into the September veto session. But when he chose to veto it before that last week, that last 6 days of activity, that immediately goes back to the House that originated it. They have a vote. It's a very simple vote. There's no committee hearings, no nothing. You just vote up or down. If the leadership brings it up, shall the governor's objections be overridden? And it was in the House. And then it goes immediately to the Senate. The Senate was still in session, and they could have voted on it, but they didn't. But I think their time's up. So I think the bill is law now.
So have you seen, certainly in the years that you were either in the courts or since then, have you seen anything that would provide some legal precedent for this situation?
No, I haven't. Just the language of the Constitution itself.
But certainly that's something that you had to consider yourself when you were on the Supreme Court, and that's how you would interpret it then. And of course, one of the anticipations is that that's where this will probably wind up, assuming the Senate moves forward with its veto override, is in the courts.
Well, there's kind of a philosophical position that people take, especially if you're in the legislative branch, that the power of the legislature is plenary. That is, it has full powers. But the provisions of the Constitution put procedural constraints on the General Assembly. So it's not that they can do anything anytime they want. They have to act within the parameters that are established in the Constitution. And one of those parameters is that if they get a vetoed bill earlier in the session than that last week, the House that originated the bill has to take it up or let it go. If the governor And the governor has 15 days. So sometimes the governors can take most of the 15 days and veto it in a way that it goes into the veto session. But in this case, he chose to veto it so that there was still enough time left in the General Assembly to take it up in the regular session.
Okay, well, I guess we'll see, of course, how this plays out then in the coming weeks. Is this something that you in your current position, do you still watch these things to see how they play out?
As a spectator, pretty much. I think it's an interesting situation, and of course, the question is whether a majority of the Supreme Court reads it the way I do. I can't predict that.
All right. Well, that's really everything we want to talk about today. Is there anything else you think we ought to say about it, or any other aspects about this that you find interesting?
I think people should just read it. There's two paragraphs that tell you everything you need to know. One of them is Article 3, Section 32, and the other one, the one that gives the governor 15 days, that's Article 3, Section 31. So there's just two paragraphs of the Constitution that you have to read. And those two paragraphs tell you everything you need to know. But they're not necessarily written like a roadmap guiding you from here to there. You have to sort of diagram it out to see, if I do it here, what happens here. So there's, but that's not interpretation. That's really just parsing out the language so that you understand what it says.
And that's usually the case, isn't it? You have to read the whole thing and figure out what parts go together. That's usually the difficulty.
Yeah, it's words, and the words are conveniently written in English. So, I assume that people can read words that are written in English and make them sound like something different than what I'm saying. But, it's a free country.
All right. Well, Dean, thank you very much for your time today. Dean Michael Wolff has been our guest, again, with the St. Louis University School of Law and a former Supreme Court Chief Justice. Thank you very much for your time today.
All right. Good to talk to you.